Welcome back to the second half of the direct examination of Robyn Denholm in the SolarCity bailout class action against Elon Musk. A 127-page conversation between Denholm and one of the lawyers for the defense, Evan Chesler. We're now at July 19, 2016 with JX1589. Meeting minutes from a Tesla board meeting, officers from Wachtell and Evercore were in attendance. Also reporting to the board was Mr. Jason Wheeler, CFO at Tesla, who discussed the financial situation at SolarCity, including a request from SolarCity that Tesla provide them with short-term bridge financing in connection with a potential acquisition to address its short-term liquidity needs, which request the company had rejected. Chesler asked Denholm, with respect to the short-term bridge financing, what was Elon Musk's position at the time with respect to whether Tesla should provide that financing. Denholm says he thought we should provide it. Chesler, and what did the board decide to do? Denholm says, not provide bridge financing. And we're going to leave this discussion here and readdress it shortly because it is a little more important than it seems for reasons we are going to make very clear later in this episode. On page 3 of these minutes, Mr. David Cart from Wachtell, the lawyers representing Tesla in this bailout, noted, in response to the financial diligence findings regarding SolarCity's liquidity needs and in an effort to encourage SolarCity to seek, as soon as possible, third-party bridge financing and amendments or waivers of covenants that may be required under SolarCity financing arrangements in connection with a potential acquisition, representatives of Wachtell Lipton had proposed revisions to the draft merger agreement, allowing the board to terminate the agreement in the event that SolarCity defaulted under its financing obligations or failed to obtain such amendments or waivers following the execution of the agreement. So even the lawyers in this transaction saw the writing on the wall with regards to SolarCity's finances and recommended an amendment that would allow Tesla to walk away from the deal if SolarCity breached debt covenants, which it had already done, or failed to get third-party financing or refinancing, which they never did receive. Yet Tesla still did not walk away from this deal. At the July 19th meeting, Evercore did another presentation, and Chesler asked Denholm what they had been learning in due diligence. Denholm mentions they were finding some items they could use to negotiate the price down, some of which referred to the Riverbend facility. We're going to skip over anything to do with Buffalo, since that arrangement was completely changed by the time the shareholder vote happened. Now keep in mind, this has been a month since Tesla put their first offer out to SolarCity, and the board hasn't heard boo from SolarCity directly. Another month of cash burn, deflecting payments to contractors, and ignoring bills from suppliers. And we know Lyndon Rive has been in touch with Musk in the meantime, as covered in Musk's testimony. But Denholm and the board have heard nothing, no counteroffer or response of any kind. Chesler asked Denholm, what was your sense of SolarCity's financial condition in the context of deciding how you were going to use it as leverage in the bargaining? Denholm says, I think their overall financial position was sound. Obviously, there were matters that we could use in terms of negotiating down the price, but they were a standalone entity. They were continuing to trade and doing well in the market. So from my perspective, they were a solid company. Chesler asked, did you think it was a good negotiating strategy to use the cash situation they were in effectively against them on the price? Denholm says absolutely. Chesler asked, why did you feel that way? Denholm answers, because our role, my role, was to get the best possible price for our shareholders. So here's our question at this point. If your job is to get the best possible price, why was Tesla offering a 30% premium on top of the top range of the stock price and was on a downward trend? Any adjustment downward on the proposal simply cut into the 30% premium they were offering based on a price that was already too high. How is that a smart way to negotiate the best price for your shareholders? This brings us to the July 24th meeting. JX1673 are the minutes, and on page 2 it is noted that Denholm had contacted Donald Kendall from the SolarCity board and special committee overseeing the deal from their end. For the first time in this trial, a counteroffer from SolarCity is brought to light. The offer was at an exchange ratio of 136, equating to $30 per share for SolarCity stock. Denholm says she suggested to Kendall that if Tesla was to make a counteroffer, it would come in lower than what they had already offered due to what they had been learning in due diligence. She says at that point the Evercore people left, and the board decided on a 0.105 share ratio, or 9.52 shares of SolarCity per share received in Tesla. As it turns out, comparing the closing values of SolarCity versus Tesla on the date of the shareholder vote, SolarCity closed November 17th at $20.90. Tesla closed on the day at $188.96, or 9.03 shares instead of 9.52 shares at regular market value, a ratio of 0.110. During the July 24th meeting, as Chesler reads from the JX, representatives of Evercore then discussed with the board the financial and operational results of SolarCity for the second fiscal quarter of 2016. Discussion ensued among the directors regarding the timing of making a potential revised acquisition proposal relative to SolarCity's upcoming announcement. And as Kimball testified, they wound up making the final offer before that announcement was made public, which served to prop up the price of their acquisition target. A terrible negotiating move, since it forced Tesla to pay yet another premium on the stock. On page 2032, Chesler is talking to Denholm about a call she made to Musk after the meeting, where she started talking to Musk about the technology assets of SILEVO. Remember, Musk was trying to broker a deal between these two companies behind the scenes, where SolarCity would sell Tesla SILEVO in advance of the bailout as another form of bridge financing. It was the SILEVO technology that got Musk into the Riverbend property in the first place. The Buffalo Billions were building a factory according to the specs of the SILEVO panel production. Question: did the board ever decide to make a separate proposal or offer for just SILEVO? Answer: we did not. Question: why not? Answer: because it would not allow us to do the integrated product that was key to the strategy. So are you following this? SILEVO, the big acquisition made the previous year by SolarCity at a cost of $350 million, the original tenant who secured the lease at the Riverbend facility in Buffalo, owners of the manufacturing technology that was going to finally give SolarCity the ability to produce its own branded panels, was somehow not going to give them the integrated product that was key to their strategy. Yet, if it's included in the overall package, then it will somehow be able to give them exactly what they're after? This makes absolutely no sense. Pages 2035 to 2047 really don't offer any new information to the discussion. Most of it is rehashing due diligence material that's already been covered. On page 2041, Chesler asked Denholm about the 7 valuation methodologies they used, but if any of these methodologies were based on SolarCity installing 1100 megawatts in 2017, they were automatically skewed by 20 to 30%. And on a $6 billion debt and stock transaction, that's another huge error. One of these valuation methodologies was based on SolarCity Management's projections of the business over time, and this was their projection range: 523 to 720 megawatts per quarter. This is the chart versus reality for the next 3 years. So those look completely realistic, don't you think? You can read the other descriptions at your leisure if you like. It's pretty dry stuff, and we all know what happened after the bailout anyway. The next discussion that introduces new material happens on page 2048, relating to a meeting on August 25th of 2016. Here is one of the important paragraphs. Mr. Francis and Ms. McBean noted to the board that Lazard had become aware of a computational error which double-counted certain amounts of SolarCity's projected outstanding indebtedness, which was reflected in Lazard's discounted flow valuation analysis of SolarCity. They also informed the board that in connection with Lazard's valuation analysis of SolarCity, SolarCity's management had prepared a separate case of unaudited financial information. Now remember that Evercore had pretty much been begging Tesla for more time to perform a more thorough due diligence. But at this point, Denholm says she got annoyed with them for not coming forward with this additional management case sooner, and with the computational error. But if Denholm was as involved in the due diligence as she claims, if she is the numbers whiz her CV would have people believe she is, why didn't she discover the significant error? So now, despite the errors, despite the falling guidance at SolarCity for 2017, despite every red flag that's come up, Tesla intends to move forward with this bailout, but this still depends entirely on a shareholder vote. In order to prepare shareholders for a vote, the company needs to create and distribute what are called proxy materials, a package for the shareholder to consider that contains all the relevant information those shareholders require to make an informed decision. They rely on the board to provide them with those facts in the proxy materials so they can make an informed decision when it comes time to vote. JX2121 is the proxy package, and this took, in Denholm's words, quite a bit of time and effort. Then she says, we needed to obviously get a shareholder vote that approved the transaction of the, majority of the disinterested shareholders. She answered questions and let the people she talked to know that she was advocating for this deal to go through. As part of this process, she also met with proxy advisors because, as she said, it's my experience that the proxy advisors are very influential in terms of the alternate institutional shareholder vote in relation to most things, including transactions of this type. She met with ISS, Institutional Shareholder Services, the same organization that has recently advocated to have Kimball Musk removed from the board of the company due to his general uselessness. And when Denholm met with these representatives, the Tesla management team was also in the room with her, and oftentimes so was Musk, not as an observer, He talked to these organizations about the strategic rationale and answered questions on the technology aspects of the deal. So this is Musk, the supposedly recused and terribly conflicted CEO, advocating directly to the shareholder organizations right in front of Denholm, who did absolutely nothing. JX2249 is the ISS report, page 15, reading, "The transaction is a necessary step towards Tesla's goal of being an integrated, sustainable energy company. Additionally, it appears reasonable to assume that Tesla is paying a no to low premium to take over Solar City." In other words, ISS completely dropped the ball on this, but another proxy advisor was consulted and Glass Lewis did a much better job in their breakdown. Their report, JX2237, is brought up. They were against the transaction and stated the following. Chief among those doubts is that the arrangement may more realistically represent a complex, high-risk bailout-buyout of Solar City by Tesla, the former of which is increasingly loss-making and cash flow negative with seemingly little standalone ability. With Solar City posting rapidly deteriorating operating metrics and managing a complex and unwieldy debt burden, considerable concern has arisen that Tesla, a firm that has also struggled to find consistent profitability while burning through a significant amount of cash, may knock itself off course at a particularly critical juncture in the service of propping up another Musk-affiliated enterprise. Basically, the analysts at Glass Lewis nailed the assessment of the situation, but Robyn Denholm says she didn't agree with that assessment. The report goes on under the heading Steeped in Conflicts, which outlined publicly available information for the board regarding Musk's shareholding within both Solar City and Tesla, and the fact that his cousins were the CEO and CTO of Solar City, and that his brother Kimball was on the board of Tesla. They went further still and outlined all the other related party transactions between members of the board or Antonio Gracias and his fund and Elon's investments in his fund. And we're not done yet. Page 7 of the Glass Lewis report has a section entitled Bailout Concerns, which Chesler asked Denholm the Coles notes for. Essentially what their summary had at the beginning, which was they believed that the cash required for Solar City was not available to them, and therefore that our acquisition was a bailout of Solar City. The last sentence of this section reads, in short then, Solar City's principal standalone business as it exists today is increasingly and materially incapable of supporting itself. Glass Lewis spelled out the exact situation of both companies in crayon. It could not have been made more clear. But Denholm, for whatever reason, completely ignored this commissioned advice because she didn't agree with it. So what does that tell you about this person who currently heads up Tesla Incorporated? When presented with an absolutely stunning and accurate assessment by paid professionals, Robyn Denholm ignores that advice and goes along with whatever her benefactor wants. There's no other way to interpret this. Now, Chesler makes a huge mistake in the dying minutes of the day, and it's one that the plaintiff's side needed to perk up on. Chesler lines up Denholm at the bottom of page 2058 for a series of rapid-fire answers. Now, in addition to meeting with and talking with the proxy advisors, I think you said you also met with a number of institutional investors of Tesla. Is that correct? Denholm answers yes. She met with T. Rowe Price, with Vanguard, with TIA CREF, the acronym for the Teacher Insurance and Annuity Association of America College Retirement Equities Fund. She met with State Street, with BNY Mellon, and with the Florida Pension Fund. And then, for those people paying attention, Chesler asked the dumbest question he could possibly ask. In any of these meetings with all those institutional shareholders, did you ever hear anyone suggest or say that they were influenced in their voting decision in any way by Mr. Musk? And the reason why this is the dumbest question Chesler could possibly ask is because we already know from Musk's testimony, through his assistant Emma Gallagher's emails, that he personally called any significant investor who was expressing doubts about this bailout. These calls were also announced by Mr. Evanson, the Vice President of Global Investor Relations and Strategy. He stated in a group email, Elon wants to do calls this week with the top 10 shareholders who have not expressed positive opinions about the deal, arranging those calls now. And Musk declared during his cross-examination with Randall Barron that he made those calls because investors needed to be educated as to the reasons for the deal. Denholm says she gave each of them quote-unquote the same presentation, but does not say what that presentation looked like. She doesn't say, for example, whether or not the assessment from Barclays was included. Fortunately, we don't have to guess what was in the presentation because we dug up that entire package. And these slides are taken directly from their S-4 form filing with the SEC, numbered 333-213390. This is a 35-page presentation from front to back, and it is rife with trigger words that almost always indicate a scam. Phrases like vertically integrated, sustainable energy, and worst of all, synergies is used on almost every page. Generally speaking, you want to avoid people who use those words. Listed on page 3 are the people who presented these frames to the proxy advisory firms. And wouldn't you know it, Elon Musk is second billing on this card to Robyn Denholm. The supposedly recused, terribly conflicted CEO and chair of Tesla is joined in this presentation by his co-opted former divorce lawyer Todd Marin and the equally co-opted CFO of Tesla Jason Wheeler, the guy who drafted up the original Project Icarus on Musk's orders during the last weekend of February. We're going to go through some of the highlights of this document found on the SEC website, starting with point 6 of the executive summary declaring that the Tesla board of directors conducted a thorough and fair process. They say over the course of many meetings and with the assistance of independent financial and legal advisors, the Tesla board of directors reviewed the strategic and financial implications of the transaction and considered its financial advisors' view that SolarCity was the most attractive asset for Tesla in the solar industry. Those independent financial advisors gave Musk daily update calls, took instructions from him on a daily basis, and had their presentation materials personally vetted by Musk before the board ever saw any of them. Those independent legal advisors were handpicked by Musk, the conflicted Gracias, and the co-opted Marin. They were also retained prior to being given the go-ahead on this deal by the board. And of course, it's ridiculous to even suggest they looked at other targets with the same vigor as they did with SolarCity. Where are the 7 valuation models on Sunrun, for example? At least under point 7, they were a little more honest. Tesla, well more accurately Musk, did conduct extensive investor outreach by calling every significant investor who had indicated they were not in favor of this deal. Later, on page 21, the presentation declared they expected SolarCity to reach cash flow break-even with cost and revenue synergies. There's that word again. To our knowledge, nowhere in the 3,000 pages of testimony in this action does anybody ever make that claim, and the revenue versus profit graph certainly does not support it. There is also a claim that both SolarCity and Tesla successfully accessed the capital markets, when we know absolutely nobody at this time was going to give SolarCity any form of financing whatsoever. On page 26, the presentation goes to great pains to attempt to indicate that Musk and Gracias had recused themselves from this transaction. So the guy who was presenting this very slide deck to the proxy advisory firms was trying to claim he was recused in this matter. Then page 29 answers the question we had before about whether or not this package was fair and balanced. It's titled Positive Investor and Market Sentiment. It takes 8 cherry-picked phrases from 7 different sources, Bloomberg was used twice, to make people reading this believe they were all in favor of this deal. However, they used a clip from Barclays in this as well, and we already know from Denholm's testimony that they were not in favor of this deal. That's why we're going to call these clips cherry-picked. But you know what this proxy doesn't include? A similar frame of all those analysts who were against the deal. Seems only fair to present a balanced opinion that such a frame should have been included, doesn't it? Generally speaking, the entire document is just cringeworthy, especially given the post-mortem of this bailout. But one other major item we observed is on page 34, SolarCity Overview. It is the last point on the page. Distribution channels include direct outside sales force, door-to-door sales, call centers, channel partner networks with Home Depot and Best Buy, and customer referral program. Almost every item on that list was gutted shortly after this bailout. The door-to-door sales program was canceled in April of 2017, 5 months after this deal was done. By June of 2018, they had abandoned their deal with Home Depot, and although great fanfare surrounded the penned deal with Best Buy in March of 2014, there's no mention on Google that this deal moved forward, or if they did, when this deal ended. However, as of today, you cannot buy any SolarCity or Tesla branded panels through Best Buy. Also, SolarCity products were supposed to be able to take advantage of the Tesla showroom network of 190 retail locations as mentioned on page 11. But that never happened either, and many of those showrooms were shut down in spring of 2019, forcing car and solar sales to the online platforms. Now, none of this is a matter of hindsight being 2020. Analysts that Denholm ignored told her this bailout was a bad idea, and history has certainly proven them to be correct. For his final trick of the opening act, Chesler is going to have Denholm go through emails and the results from the shareholders' vote on November 17, 2016. JX2308 is a compilation of emails between Todd Marin, Musk's co-opted lawyer friend, Antonio Gracias, recused co-conspirator, Brad Buss, who sat on both company boards over time, and Musk himself. The section Chesler reads off is, "We'll get the final numbers at 1 p.m. While paranoia remains firmly in place, this should be very close to final." The tally at the time was 12 million shares voting against, 70 million shares voting in favor, passing the bailout with 85% approval, which was recorded on an SEC 8K form the following day. But here's what most people casually observing this trial don't realize. is that if Musk or the board withheld or failed to provide these shareholders with truthful and complete information proxy materials regarding this bailout, this vote can be, and should be, overturned by the courts, as Sykes recorded in his pretrial decisions. Court adjourned for the day at 4:43 p.m. before Chesler was finished with Denholm, who has already been on the stand 3 times longer during her direct than Musk was. When court returned the next day, Chesler still had a couple more questions for Denholm, starting with her role with the audit committee at Tesla, which is to oversee the financial processes that the management puts in place, so to ensure that they're doing their jobs in terms of the financials of the company, internal controls, and that kind of thing. She's asked if she recalls Ernst & Young being auditors for SolarCity at the time of the bailout. She says she did. She's asked if she saw that E&Y made a final determination of concern whether or not SolarCity was a going concern. She says she did see it. Then Chesler asked Denholm about a single notation in this report that reads, "We did not identify any events or conditions that led us to believe there is a substantial doubt about the company's ability to continue as a going concern for a reasonable period of time." This statement is worded in an ambiguous manner, does not state what they're referring to directly, and has no other context associated to it during this discussion. Yet we know from other reports and Musk's testimony that E&Y's report determined in no uncertain terms at the end of the day that SolarCity was insolvent and unable to survive on its own, as identified also by Glass Lewis. Even George Belichick, the banker on the SolarCity side of the deal, knew that SolarCity was going to die. Then Chesler asked Denholm about the role KPMG played in connection with the bailout, and that they were retained to perform a valuation of the assets, including the intangible assets that actually are then recorded into the books of the acquiring entity as a way to close off the transaction. So a tangible asset would be something like a building or a truck. An intangible asset would be something like goodwill or the IP on the vaporware scam solar roof tiles that Musk presented to shareholders just prior to their vote in November. Which is probably how they got to a valuation of $2.2 billion in assets for a company that at that point in time had no manufacturing capability, no proprietary tech, and a balance sheet that was in free fall, showing never having made a dime in profit. KPMG didn't even get the purchase price right. Nobody else assessed it at $2.1 billion. Every other report pegged it between $2.6 and $2.8 billion. So instead of their reported gain of $89 million in assets as a result of this bailout, the balance sheet should have shown an instant loss of over $500 million, even if they could justify the $2.2 billion evaluation of the company assets. Which makes you wonder if KPMG thought that Tesla owned the billion-dollar factory being built to their spec, but still owned by the state of New York. And if that's the case, their assessment was off by $1.5 billion. This is the final discussion between Robyn Denholm and her friendly lawyer, Mr. Chesler. Next up is Daniel Berger for the plaintiffs, and he's got a lot of material to go through with Denholm before her time on the stand is done. That cross-examination is up next. For now, we're in recess.